Greetings everyone. Today I'm going to talk to you about criminal negligence and what part of the legal system applies to it, and the difference between criminal negligence and civil negligence. Criminal negligence is a section of the Criminal Code of Canada, section 219, that reads as follows. Everyone is criminally negligent who, A, in doing anything, or B, in omitting to do anything that is his duty to do, shows wanton or reckless disregard for the lives or safety of other persons. And 2 defines duty. It says for the purposes of this section, duty means a duty imposed by law. And that is section 219 of the Criminal Code of Canada. So, because this is an offense under the Criminal Code of Canada, it is a criminal offense. As somebody who is a victim of negligence, you also have the ability to sue in civil court. There's what's known as civil negligence. Civil negligence is very easy to prove if the party that you're suing has already been convicted of criminal negligence, because negligence has already been established. So I'm going to explain what civil negligence is. The easiest way for me to do this, though, will be in the process of explaining and defining criminal negligence, because they're like yin and yangs. One is in one court and the other is in the other court, be it criminal or civil. So at this point, I'm going to go to the case law. Before I do that, though, there's one thing I should go over, and that's actus reus. And that's a term that's used in the courts and in our legal system, and what it means is wrongdoing. Any activity that transgresses moral or civil law. Actus reus. So, the first case that I'm presenting is Regina versus Gossett, 1993, Supreme Court ruling, Supreme Court of Canada. So this is our highest court in the land. Now, what matters is what a judge said or what was accepted in court. A police officer, their job is to enforce the laws. And if they're unsure of something, or if they're not familiar with something, you may get false information from a police officer because they may not know, they may not have ever had to deal with actual criminal negligence. It may even go as far as for them to tell you that it's a civil matter and that you need to contact an attorney. Now you'll see Section 86 of the Criminal Code referred to in this section, and that's referring to the specific crime that was committed in this case, and they're trying to determine whether negligence, criminal negligence, was a factor in the crime, which is a violation of Section 86, 86.2. You can research this under the Criminal Code. I'm not going to get into that at the moment. What interests us for our purposes in this case is its reference to criminal and penal negligence. So in this section, the objective test, they're saying that it says, while identifying the objective basis for the determination of fault under Section 86.2, the case as noted above tend to conflate the civil standard of negligence with the test for negligence in criminal law. Negligence in a criminal setting, or what I shall hereinafter refer to as penal negligence, to distinguish it from other offenses involving a fault element of criminal negligence under Section 219 of the Code, subjects those convicted to the possibility of imprisonment. Unlike negligence under civil law, which is concerned with the apportionment of loss, penal negligence is concerned with the punishment of the moral blameworthiness. The practical implication of the distinction is that a finding of negligence under the Code, whatever degree or species of negligence is contemplated by the charging section, is made somewhat differently than a finding of civil negligence. Penal negligence incorporates the particular frailties of the accused, if any, because he or she could not have acted other than they did in the circumstances. This approach prohibits punishing the morally innocent So we have a fair justice system in Canada, and this is why, because they don't just put you on in court and say you're guilty. They do everything possible to see how you could be guilty, yes, because they want to prove beyond a reasonable doubt, but in the same step, your defense is proving that you're innocent beyond a reasonable doubt. So it's a fair and just system. Now I'm going to go into more depth about criminal negligence, and I'll come back to civil negligence later once I've gone over this. This is a different case than the one I was just referring to. This is Regina versus JF in 2008, and this is also a Supreme Court of Canada ruling. This case is very interesting because it's about a parent that didn't provide the necessities of life for a child. So there's two crimes that have happened here: criminal negligence and failing to provide the necessities of life. We are going to look at the criminal negligence aspect of this case, of course. It reads, turning to the offense of criminal negligence, the actus reus will be established if it is proved, 1. That the accused was under a legal duty to do something, 2. That from an objective standpoint, he or she failed to perform the duty, and 3. In failing to perform the duty, he or she showed, again from an objective standpoint, wanton or reckless disregard for the lives or safety of other persons. See another term coming, mens rea. I'm going to go over that before I continue. Mens rea is a noun that means the intention or knowledge of wrongdoing that constitutes part of a crime, as opposed to the action or conduct of the accused. So it says proof of the mens rea will flow from a finding that the conduct of the accused was wanton or reckless. Wanton or reckless behavior has been equated with a marked and substantial departure from the norm, which necessarily includes behavior that constitutes a marked departure. So what this means is if your behavior has been found to be wanton or reckless, then it's proof of mens rea. It's proof that you had either intention or knowledge of what you were doing, and this is accepted by the courts. Up until now, everybody may have been curious about what actually wanton or reckless disregard means. Well, it is defined in this case. Wanton disregard means the heedless disregard for the consequences of your failure to act, and reckless means showing indifference to the consequences of your failure to act. Criminal negligence requires more than just carelessness. Again, this case has to do with a parent not providing the necessities of life for a child. However, it does apply to other criminal negligence aspects in our society. So, it is said here that Crown Counsel may prove this either of two ways, in either of two ways. By proving that JF was aware of a danger or risk to the health or safety of KM, that was the child, but ignored that risk, or by proving that JF failed to direct his mind to the risk to the health or safety of KM, which a responsible parent would have understood. So again, that has to do with the parent aspect of things, but if you take JF and you take KM and you plug in other variables, be it WorkSafe New Brunswick or some other company or some other person, if you put them in those places, then you can use that to determine what would have to be proved in a case against WorkSafe New Brunswick to show criminal negligence. Crown Counsel does not have to prove both. It is enough for Crown Counsel to prove one or the other, nor does everyone have to agree on which one Crown Counsel has proven, as long as each of you is satisfied that one or the other of them has been proven beyond a reasonable doubt. So you don't need to prove both. One or the other is sufficient to prove criminal negligence. Now, civil negligence, if, for example, you're in a car accident and you're sued because you were in the wrong. Well, being in the wrong in a car accident technically is civil negligence, That's what puts you in the wrong. Now, under certain circumstances in car accidents, and if you do search on CANLE for criminal negligence, you'll find a lot of motor vehicle accidents where criminal negligence has been applied. So, when you're civilly negligent, there is a chance that you're also criminally negligent. However, if you are criminally negligent, then you were automatically civilly negligent. The criminal code comes first. Civil negligence in civil law is to protect your pocket, basically. It's to protect money that you may have lost or may not have occurred because of somebody's negligence. Criminal negligence is the act of the crime that put you in the situation which allowed you to lose the money that you would sue for under civil negligence. So criminal negligence is a section of the criminal code. Therefore, it is a criminal offense and therefore should be dealt with and is dealt with by the criminal courts. If you've been told by a police officer or by somebody of legal authority that criminal negligence is a civil matter, then that person is incorrect. They don't know what they're talking about in that case. Now, if you're unaware of the criminal code and it is your job to enforce the criminal code, then before you jump to say that something is civil, like criminal negligence that has criminal right in the title of the offense, perhaps you should check your book or your document that you have, your PDF like I'm using for criminal negligence, so that you don't risk making yourself look foolish, as it is your job as a police officer to keep us safe and to enforce the criminal code. The question that becomes is, how do you enforce the criminal code if you do not know the criminal code? The answer is an easy one. You can't. The only way that you can enforce something is if you know what you're enforcing. Now, in the defense of the police officers and those people that may not be aware, the criminal code is at 1,019 pages. It's not a light document. It's not your light reading that you take to the washroom with you. It is intense. It is a very thick book. So, that being said, there are professions out there that absolutely cannot remember everything that they need to know. And some examples are doctors, computer technicians. Those people, there's just too much information for them to keep it all stored. So what they do is when a doctor needs to do a procedure or they need to do something that they're not familiar with, and they're doctors, they know the ins and outs, but they need to actually find out what to do, they look it up. They go and they find the answer. Now, could you imagine if you went to a doctor, and maybe that happens because there's malpractice, but could you imagine if you went to a doctor and he made a guess rather than looking it up and turned you away? And then because he guessed, and because he turned you away, you died. Well, that would put the doctor in a position of criminal negligence. In society, in the jobs that people have, you will find people that are your slackers, the people that are lazy. They don't want to work. They just want to collect their paycheck. That happens in every profession, unfortunately, and that may be the case if you've ran into a police officer that's given you misinformation, where they've said that something such as criminal negligence is a civil matter, or you may have been told that it was criminal negligence that was a civil matter. They should have gone and looked up the law. They should have looked up the criminal code section. They should have done some research on the case law, because they have access to CANLE the same as what we do. And police officers are not lawyers in their defense. That may not be their job. But as a department that enforces law and legislation, if they're not the ones that do that research, then we as a society need to look at possibly creating those positions among our law enforcement to do that research. And I'm pretty sure that they already have those positions and those research people. It's whether or not they choose to use them or they make a quick judgment. That's what it comes down to. It's the job of the police and the Crown prosecutors to enforce the legislation and the criminal code. They don't get to pick and choose which laws that they enforce and which ones that they don't. They have to enforce them all equally. So, a police officer that is told of a case of criminal negligence and is shown evidence of such criminal negligence should be every bit as concerned for the victim as what he would be if it were a case of rape that was reported, where somebody had been raped and there was evidence because they could do a kit. Because laws have to be enforced equally, and there's immediate danger. So that being said, if the victim is still in immediate danger, there should be a sense of urgency besides that. That may give the illusion that certain laws are not enforced equally. However, when it comes to the criminal code and it comes to the sections of the criminal code, every section must be enforced equal to every other section, regardless of the crime, in order for us to have a free and just society. So if you've been told by a police officer that a criminal offense that you are a victim of is a civil matter, and that you need to contact a lawyer to sue this person in a civil court, speak with an attorney, rather than with a police officer because you're a victim of a crime. If they've given you this misinformation, they need to be corrected, because it's the only way that our justice system is going to improve and that this is going to stop. Imagine how many people are pushed away by the police because they don't know of the crimes which have been committed to be able to enforce the criminal code. So if this has happened to you, I'll put the link in the video links below, and you can go to the New Brunswick Police Commission website, as well as you can contact them directly and file a complaint against your officer that gave you the misinformation. It is the only way that our justice system is going to improve, and those officers are going to be educated on what they need to do to be able to properly enforce the criminal code. In conclusion, never take what you are told at face value if you know different. If you suspect that it may be incorrect, then you owe it to yourself to do your research and to prove it either to be correct or incorrect. If you have a gut feeling that something has been done wrong, then there's a very good chance that something has been done wrong. That being said, if you go to the police and you believe you're a victim of a crime, the police officer should, if nothing else, show you where it is not a crime and it is a civil matter if they're claiming that it is civil, rather than just pushing you away and saying that it's a civil matter. Police officers have a duty to protect us. Their job is to protect the public and keep the public safe. Turning you away if you are a victim of a crime and telling you that it is civil is a failure to do their jobs. We need a fair and just society, and we need those people who enforce the legal system to be properly educated on how to do so. I thank you for your time, and have a good day.